Namaste, Namaskar, Assalamu alaikum and Vanakkam friends. Is my audio clear? Am I visible to you all? Yes, yes. Okay. Friends, today's class is on set-off and counterclaim. The concept of set-off and counterclaim, these two concepts are very important in the part of pleadings under the Code of Civil Procedure 1908. Friends, let us discuss the concept of counterclaim. Set-off and counterclaim with regard to C.P.C. Friends, Order 8 rules 6A. Okay. Order 8 rules 6A to 6G. These are pertaining to the concept of counterclaim, friends. These are related to counterclaim. Okay. Now, in the light of the Bear Act 19, in the light of the Bear Act 1908, that is C.P.C 1908, let us discuss the concept of counterclaim first. Okay. Friends, Order 8 is exclusively dealing with the concept of written statement, the contents, mode, etc., along with the alternatives of the written statement, especially the name of counterclaim, etc. Rule 6A. The title of Rule 6A is that counterclaim by defendant. Friends, first let us understand the steps involved in a civil case very simply. Okay. Friends, in a civil case, generally, first, a plaint will be presented by the plaintiff. Okay. If it is in accordance with the rules prescribed for pleadings, okay, it is in accordance with the C.P.C and civil rules of practice, and if it is filed within the period of limitation and the court fee is properly paid, then the plaint will be numbered and a suit number will be assigned to the plaint. Now it will become a original suit, friends. If everything is proper, then the court admit the plaint and gives a original suit number to the plaint. Okay, then it becomes OS, friends, original suit. The court assigns a number, OS number 1 of 2021, OS number 2 of 2020. In the suit register, every plaint may be recorded and a suit number will be assigned to each plaint if it is properly presented in the manner which is prescribed under C.P.C and civil rules of practice. Once the plaint is filed, then the summons may be served upon the defendant. Okay. Once the summon is served upon the defendant, once the summon has been received by the defendant, then the summon says about the date of appearance before the court of law. Generally, the contents of the summon are that please take the summon that the above named plaintiff has instituted a suit for recovery of money or for declaration, for permanent injunction, for partition, for foreclosure of the mortgage property. Okay, so likewise, the plaintiff may file a plaint. Here, the contents of the summon or that, okay, the above named, please take the summon that the above named plaintiff has instituted a suit for so and so relief. against you. Therefore, you have to appear before the above named court on so and so date at 10:30 a.m. Okay, forenoon session without fail. Or you may appear before the honorable court in person or through an advocate. If you fail to appear before the honorable court on the said date, your case will be heard in your absence. Your case will be set ex parte. Generally, these are the contents of the summon. Friends, once the summon has been received by the defendant, then he will appear before the court, or he may engage an advocate. Then his advocate will file a wakalat. Thereafter, from the date of service of the summon, he will have 90 days of time to file his answer. It is known as a written statement. It is known as, first it is plain, friends. Then the written statement. Once the written statement has been filed, then after receiving the written statement, then the court may post the case, the civil case, for settlement. For settlement of terms between plaintiff and defendant as enumerated under section 89 of C.P.C. The court may post the case for settlement of any terms between the plaintiff and defendant. If both the parties report no settlement, then the court may post this matter for framing of issues. Once the court frames the issues, or any party to the suit may also file a draft issues. Based on the draft issues, frame the issues. Once the issues are framed by the honorable court, then issues are framed for the suit is posted for trial. Friends, trial means evidence of the plaintiff and evidence of the defendant. Evidence of the defendant. Therefore, friends, both the plaintiff as well as the defendant have to they have to produce their evidences, their witnesses before the court of law. Okay. Trial means producing the evidences of both the parties. Once both the parties have adduced their evidences, first, generally, friends, we need to study the concept of burden of proof and onus of proof in Indian Evidence Act in order to know about who has to commence the trial first. Okay. Okay. As per the concept of burden of proof and onus of proof, once a party has adduced his evidence, general rule is that, friends, plaintiff first adduces his evidence. The plaintiff himself may give his evidence as plaintiff's witness number 1. Thereafter, he may introduce the another witness on his behalf as plaintiff's witness number 2. Number 3, once his evidence has been closed or he failed to adduce the further evidence, then the court may, its suo motu power, may close the plaintiff's evidence. Okay. The suit is posted for further evidence of plaintiff. No representation. The plaintiff called and absent. No representation. Hence, it is treated that plaintiff has no further evidence. Therefore, the suit is posted for defendant side evidence. Or the plaintiff may himself or his advocate may submit the honorable court that there is no further evidence on behalf of the plaintiff, Your Honor. Once the same has been submitted to the honorable court, then the case will be posted for defendant side evidence. Once the defendant has adduced his evidence, then Trial means adducing the evidence of both the parties to the suit. Once the evidence has been closed, then the suit will be posted for arguments. Friends, once both the parties have addressed their arguments before the court of law, then the matter will be posted for judgment. Okay, the matter will be posted for judgment, friends. This is the general procedure in a nutshell, okay, for judgment. The court will pronounce the judgment based upon the evidence of the plaintiff, evidence of the defendant, based on the pleadings in the plaint. These are the pleadings of the defendant. Written statement comprises of the pleadings of the defendant based on the plaint, written statement, based on the evidence of the plaintiff, based on the defendant, based on the evidence of the defendant. Okay, the court will answer all the issues after addressing the arguments by both the parties. Here, the judgment reflects the answer for every issue, friends. The reason behind pronouncing a particular decree has been very elaborately discussed under the concept of judgment. Now, our today's concept is this one. Once the plaint has been presented by the plaintiff, okay. Good evening, Joy Rita ji, very good evening. Once the plaint has been presented by the plaintiff, now it is the duty of the defendant to submit his version, his answer to the honorable court. If he fails to submit his answer, his written statement to the honorable court against the version of the plaintiff, then the court will set ex parte. The court will set the defendant ex parte, then the defendant will remain ex parte. Then, as per the version of the plaintiff, okay, the averments of the plaint are not challenged by the defendant. Therefore, a favorable judgment may be given by the honorable court in favor of the plaintiff if the plaint is properly framed. Okay, after adducing his ex parte evidence. Now, this is the rule, friends. Here, the written statement, today's class is pertaining to this concept, written statement, okay, written statement. Order 8 is completely related to written statement. Order 7 is completely related to the plaint. Now, friends, under written statement, the general rules are something. Now, we have to know about, okay, the alternatives of the written statement or the other ways to file the written statement in a suit. Counterclaim is a way, friends. Filing a simple answer denying all the facts of the plaint is one way. Filing a counterclaim, filing a written statement by way of a counterclaim is the other way. Filing a written statement by way of set off is the another way. Now, in this class, we will be discussing filing a written statement by way of a counterclaim and set off. Okay. Now, let us see. Section 6A to 6G of C.P.C. Order 8, Rule 6A to 6G of C.P.C. are dealing with the concept of counterclaim. According to 6A, counterclaim by the defendant. This is the title, friends. This is the title. Now, let us see its ingredients in the light of the Bare Act. Okay. A defendant in a suit may, in addition to his right of pleading a set off under Rule 6, okay, a defendant in a suit may, in addition to his right of pleading in a set off under Rule 6A. Therefore, friends, let us discuss the concept of set off first. Okay. Thereafter, we may jump into the concept of the counterclaim. Okay. Now let us see the concept of set off. Order 8, Rule 6 is dealing with the concept of set off, friends. Now, set off is a defense. It is a defense, friends, against the plaintiff's action. Okay. It is a defense against the plaintiff's action. Here, the speciality of the set off and the quality or the characteristic which differentiate the set off from the written statement is that there must be some reciprocal debts. In between, or reciprocal monetary transactions between the plaintiff and defendant, friends. Wherever there is a reciprocal debts in between the plaintiff and defendant, then only the concept of set off can be initiated as a defense against the plaintiff's action in his plaint. Now friends, here A has borrowed certain amount from Mr. B. Okay, A has borrowed certain amount, 1000 rupees, from Mr. B. B has also borrowed a sum of 50,000 rupees from A. Now there are reciprocal debts, friends. Now this 1000 is the debt of Mr. B. This 5,000 is the debt of Mr. A. These debts are reciprocal. These are in between A and B only. Now under these circumstances, if the transactions are related to only money, under those circumstances, friends, not only denying the contents of the plaintiff, the defendant can also fix a special defense against the plaintiff's action. The essential one is there must be some reciprocal debts. Now, for instance, Mr. A has filed a suit against Mr. B. Okay. Now, kindly forget about this illustration, friends. Okay, this is related to the concept of set off. Now, let us see the general one. A has instituted a suit against Mr. B. According to Mr. A, B has borrowed a sum of 50,000 rupees from him on 1/1/2020. He has borrowed this 50,000 rupees on 1/1/2020 for Mr. B's family necessities. Mr. B has also voluntarily accepted that he will ready to pay the 50,000 rupees along with its interest at a rate of 24% per annum whenever Mr. A or any other person on behalf of A demands for the same. Further, Mr. B has also undertook the same by way of executing a promissory note in presence of an attestor and a scribe. Now, in spite of several requests or demands made by Mr. A, B did not pay either the principal amount of this 50 lakh rupees or its interest. Therefore, Mr. A think that it is not safe to sit idly without instituting a suit. Therefore, Mr. A has instituted a suit against Mr. B for recovery of this 50,000 rupees. This is the promissory note mentioned 50,000 rupees along with its interest from 1/1/2020. Now he has instituted a suit before the court of law. This is the plaintiff, friends. Now B may deny all the contents of the plaint. Okay, I have never borrowed 50,000 rupees from Mr. A. I have never accepted to pay its interest also. I have not borrowed any amount on 1/1/2020. I have not executed any promissory note in respect of the alleged 50,000 rupees amount. Okay, the alleged attestor, the alleged scribe, as mentioned in the plaint, or the henchman of Mr. A. I have no acquaintance with them. Therefore, Mr. A, along with the alleged attestor and the alleged scribe, all of them, Mr. A and the alleged scribe and the alleged attestor have colluded with each other, and they have filed a false claim against me in order to defame me in the society. Mr. A has no such financial capacity to lend such huge amount. Okay. Therefore, the Honorable Court may please to dismiss the suit with cost. Generally, this might be the version of Mr. B in his written statement, or he may take the plea of forgery also. The said promissory note is a forged one. The signature, the alleged signatures found on the suit promissory note do not belong to me. They are ranked forged one. Such terminology can also be used by may be used by Mr. B in his written statement. It is one way, friend. Simply he is denying all the contents of the plaint. But whereas in case of a set off, Mr. A has borrowed 1,000 rupees from B. Therefore, B has instituted a suit before the court of law. B has filed a suit. He has mentioned in his plaint that Mr. A has borrowed a sum of 1,000 rupees from me for his family necessities and agreed to pay the same with interest at a rate of 24% per annum whenever I demand for the same. Okay, in spite of repeated requests, he didn't pay either the principal amount or its interest. He has also executed a promissory note in respect of this transaction on the event date in the presence of so and so persons. In spite of the repeated request, despite repeated requests, Mr. A didn't pay even a single paisa towards the principal or the interest. Under these circumstances, I have knocked the doors of the Honorable Court for recovery of money based on the promissory note. This is the version of Mr. B. Now, Mr. A has filed a written statement by way of set off that Mr. B has also borrowed a sum of 5,000 rupees from me, 500 rupees from me. Therefore, the remaining 500, I am ready to pay the remaining 500 rupees, or the Mr. B has to, Mr. B's 1,000 may be set off with my 500 rupees. In this way, Mr. A can file his written statement. It is known as a set off. It is known as a set off. Now, if the jurisdiction of a court to entertain a particular case, here the monetary jurisdiction is only for example, Mr. A has filed Mr. B has filed a suit against Mr. A, okay, for recovery of 10,000 rupees or 1,000 rupees only, okay. But Mr. A has instituted a counterclaim by way of set off for 5,000 rupees. Now, friends, if the pecuniary jurisdiction of the Honorable Court is not more than 1,000 rupees, for instance, just assumption, friends, if the court has no pecuniary jurisdiction to set off this 5,000 rupees with this 1,000 rupees, then such kind of set off cannot be sought for before the same court. Mr. A has to institute a separate suit against Mr. B in a civil court having competent jurisdiction to entertain this case. Okay, this is the important principle, friends. Now, good morning, Joy Rutaji. Good morning, friends. Therefore, the set off, in order to use set off as a defense against plaintiff's action, here there must be an ascertained value, friends. There must be an ascertained value. Without ascertained value, the claim will not be permitted. Here, it is only money. It is also money. It can be ascertained. It can also be ascertained. For unascertained values, set off cannot be put as a defense against the plaintiff's action. Okay, friends, I think you got the point. Friends. Now, there are two kinds of set offs: legal set off and equitable set off. Okay, as per today's session, okay, we don't have that much of time to discuss all those. Now, let us see the concept of counterclaim now. Now, written statement after filing of the plaint, a defendant has his right to file his written statement, a mere written statement, or a written statement by way of counterclaim, or written statement filing written statement by way of a set off, as we discussed earlier. Now, let us see the concept of counterclaim from 6A to 6G, Rule 6A to 6G of Order 8 of C.P.C, friends. Now, a defendant in a suit may, in addition to his right of pleading set off under Rule 6, okay, this is over. A defendant in a suit may set up by way of counterclaim against the claim of the plaintiff. It is a counterclaim against the claim of the plaintiff, friends. Any right or claim in respect of the cause of action accruing to the defendant against the plaintiff either before or after filing of the suit. But the condition is that, this is the condition, friends, but before the defendant has delivered his defense, or before the time limited for delivering his defense has expired, but before the statutory period to submit his version, before the period of limitation for delivering his defense, if he files any counterclaim against the claim of the plaintiff, whether such claim is for damages or for any other declaration or etc. and etc., it is irrespective of the fact, friends. But he can file a counterclaim in addition to filing a mere statement or by way of a set off. He may have the another option to file a counterclaim. Now, provided that there is a provision, friends, counterclaim shall not exceed the pecuniary jurisdiction of the court. Okay, shall not exceed the pecuniary limits of the jurisdiction of the court. Therefore, if the plaintiff files a case against the defendant Okay, if the plaintiff files a case against the defendant subject to certain pecuniary jurisdiction, if the defendant wants to, okay, file his answer by way of counterclaim, the value of his counterclaim must be within the limits of the jurisdiction of the court, as we discussed earlier with regard to the set-off. His claim shall not exceed the pecuniary limits of the jurisdiction of the court, friends. Therefore, if his claim is more than the pecuniary limits of the jurisdiction of the court, then he may have another option to file a fresh suit, a suit afresh against the plaintiff separately before a civil court, which is higher in the hierarchy of the civil courts. He has to file a separate suit, a fresh suit against the plaintiff in the civil court having pecuniary jurisdiction to entertain the case. This is one thing, friends. Here, such counterclaim shall have the same effect as the cross suit. Therefore, friends, once a suit has been filed, it will be numbered as OS number. A number will be assigned, as we discussed in the starting of the class, that once a plaint is properly filed, a OS number will be assigned. Okay, friends, once the defendant has filed his counterclaim, then the counterclaim shall be treated as a separate plaint, friends. Therefore, a cross suit number should be assigned to the counterclaim. Okay, I think you got the point. This is the original suit, this is the cross suit. Okay, counterclaim is a cross suit, friends, so as to enable the court to pronounce the final judgment in the same suit, both on the original claim as well as on the counterclaim. Therefore, for original claim, a original suit number will be assigned. For counterclaim, a counter suit number will be assigned. CS number will be assigned for the counterclaim. OS number will be assigned to the original claim. Original claim is nothing but the claim of the plaintiff in his plaint. Counterclaim is nothing but the counterclaim filed by the defendant by way of a written statement in his cross suit. Okay. Thereafter, friends, the plaintiff shall be at liberty to file written statement in answer to the counterclaim of the defendant within such period as may be fixed by the court. Here, plaintiff shall be at liberty to file a written statement. Here, first plaintiff files a plaint, thereafter a written statement, that is a counterclaim by the defendant. For the counterclaim, in order to deny certain facts in the counterclaim, a plaintiff can also file a written statement to the counterclaim of the defendant, written statement of the plaintiff to the counterclaim of the defendant. This is the title of his written statement, friends. Once the counterclaim has been filed by the defendant, then in answer to it, okay, in order to put up a separate defense for the counterclaim of the defendant, plaintiff shall have a liberty to file his written statement in answer to the counterclaim of the defendant within a period as may be fixed by the court. But as fixed for the written statement, that is 90 days, initially 30 days, or it may be extended up to 60 more days. That is up to 90 days, a defendant can file his written statement. But whereas in answer to the counterclaim, a plaintiff has liberty to file a written statement against the counterclaim of the defendant. In order to file his written statement in answer to the counterclaim of the defendant, no statutory time is fixed by the court. It is also important principle, friends. The counterclaim shall be treated as a plaint and governed by the rules applicable to the plaints. Okay, therefore, the counterclaim shall be treated as a plaint. What does it mean? It means that a counterclaim shall be treated as a plaint. Therefore, the counterclaims shall comprises of the name of the parties. It should say about the cause of action. It should mention the limitation. It should the defendant who files the counterclaim should pay a separate court fee. Okay, he has to issue the summons to the defendant, but to the plaintiff. But it is not necessary to service someone. Already the plaintiff engages an advocate. Through the advocate, he presents a plaint, friends. Therefore, before filing of a counterclaim, he may issues, the defendant may issue, he may issue a copy of the counterclaim to the plaintiff's counsel. Therefore, a separate court fee is necessary. Limitation has to be specially mentioned. Cause of action should be specially mentioned. A separate prayer can also be mentioned in the counterclaim, friends. Therefore, the counterclaim shall be treated as a plaint and it is governed by the rules applicable to the plaints. Okay. Thereafter, friends, 6B. Okay. 6B of Rule 6B of Order 8. Where any defendant seeks to reply upon any ground as supporting a right of counterclaim, he shall, in his written statement, state specifically that he does so by way of counterclaim. Here, this is a mode, friends. This is a mode. If he wants to file a counterclaim by way of written statement, he can also set the counterclaim by way of a written statement, not with a separate name of counterclaim. It is stated under Rule 6B of Order 8, friends. Exclusion of counterclaim. Exclusion of counterclaim. Where a defendant sets up a counterclaim and the plaintiff contends that the claim thereby raised ought not to be disposed of by way of counterclaim, but in an independent suit. The plaintiff may, at any time before the issues are settled or before the issues are settled in relation to the counterclaim, apply to the court for an order that such counterclaim may be excluded. Here, therefore, friends, under Order 8, Rule 6C, the plaintiff has at liberty to file an interlocutory application before the Honorable Court for an order that the counterclaim may be excluded. The counterclaim may be excluded. But this interlocutory application must be filed by the plaintiff before the issues are settled in relation to the counterclaim. Before the issues are settled in relation to the counterclaim, friends. And once the interlocutory application has been filed by the plaintiff for exclusion of the counterclaim on the ground that such counterclaim should be filed by way of an independent suit, and the court may, on hearing such application, may make such order that this counterclaim shall be excluded and the defendant is at liberty to file an independent suit against the plaintiff afresh. Okay, such kind of orders may be passed by the Honorable Court as under Rule 6C of Order 8 of C.P.C, friends. Friends, 6D. Rule 6D is related to effect of discontinuance of suit. Okay. If in any case in which the defendant sets up a counterclaim, the suit of the plaintiff is stayed. It is the important one. If the suit of the plaintiff is stayed, if a stay is granted against for with regard to all the proceedings in the suit of the plaintiff, or it is discontinued or dismissed, counterclaim may nevertheless be proceeded with. Therefore, friends, as we discussed earlier, counterclaim is a cross suit. It is a separate claim. It is a separate claim made by the defendant against the plaintiff's version. It is not only the defense, friends. It is a counter. It is a counter attack on the plaintiff. It is not only defense. It is not only it is not only a sword. Sorry, it is not only a shield. It is a sword also. The counterclaim is a separate suit. It is a separate claim. Therefore, if the suit of the plaintiff is stayed, the court can proceed. The court can proceed the proceedings in the counterclaim, even though the plaintiff's suit is stayed by a stay order of the superior court. The proceedings in the counterclaim may be proceeded with without considering such stay order. Why? Because counterclaim is a separate suit. Under counterclaim, a separate court fee is also paid. It is a cross suit, friends. It is a cross suit. Therefore, no stay order, no stay order in the suit of the plaintiff can stop the proceedings in counterclaim. This is one rule. Even though the plaintiff suit is discontinued, counterclaim may be proceeded with. It is a separate suit. It is a separate proceedings. Once the suit of the plaintiff is dismissed, counterclaim may be proceeded with. Even the plaintiff suit is dismissed for default, but counterclaim shall be proceeded with in accordance with the rules. Therefore, counterclaim is a separate suit, friends. It is a cross suit. It has a separate claim. Now, default of the plaintiff to reply to the counterclaim. What will happen if the plaintiff fails to reply to a counterclaim? Okay, it is stated under 6E, Rule 6E of Order 8 of C.P.C, friends. If the plaintiff makes default in putting in a reply to the counterclaim made by the defendant, the court may pronounce the judgment against the plaintiff in relation to the counterclaim made against him, or make such order in relation to the counterclaim as it thinks fit. Therefore, friends, giving a reply to a counterclaim is mandatory for the plaintiff. It is a fatal to the plaintiff. If the plaintiff fails to offer a reply by way of a written statement in reply to the counterclaim of the defendant, then plaintiff's version or the plaintiff will be set ex parte in the counter claim also. Okay, therefore, the court may pronounce a judgment against the plaintiff in relation to the counterclaim made by the defendant against the plaintiff, or the court may make some such orders in relation to the counterclaim as it thinks fit, friends. Therefore, this is its importance. 6F and 6G are also dealing with the concept of counterclaim. Okay, friends, according to 6F, relief to the defendant where counterclaim succeeds. What will happen if the counterclaim? What will happen if the version of the defendant is succeeded before the court of law. It is stated under 6F of the Act, friends. Friends, according to Rule 6F, where in any suit a set off or counterclaim is established as a defense against the plaintiff's claim, and any balance is found due to the plaintiff or to the defendant, as the case may be, the court may give the judgment to the party entitled to such balance. Okay. It is related to the balance amount. Therefore, the court may give the judgment to the party entitled to such balance. In case of set of friends, it is applicable. Okay. The plaintiff files a suit for recovery of 5,000 rupees from the defendant. Defendant has also filed a set off for 2,500 rupees. Then the court may give the judgment to the plaintiff entitled to receive the remaining balance of 2,500 rupees from the defendant. Okay, it is general. It is very general. 6G, friends. Rules relating to written statement to apply. The rules relating to written statement by a defendant shall apply to the written statement filed in answer to a counterclaim. Therefore, the written statement filed in answer to a counterclaim. Who files this written statement in answer to a counterclaim? The plaintiff files a written statement in answer to a counterclaim, friends. Therefore, any written statement filed in answer to a counterclaim by the plaintiff, all the rules related to the written statement to apply to the same. Okay, it is about 6G of the Act. Now, these are 6A to 6G of Order 8 of C.P.C. are exclusively dealing with the concept of counterclaim, friends. Counterclaim. 7 is related to defense or set off founded upon separate grounds, where the defendant relies upon several distinct grounds of defense or set off or counterclaim founded upon a separate and distinct facts. They shall be stated as far as may be separately and distinctly. It means that the grounds that if he wants to use a separate ground of no consideration is passed. Okay, it is a forgery. Minority, or he may take unsoundness of mind, or he may take the ground of coercion, fraud, misrepresentation. Therefore, such kind of defenses shall be mentioned separately and distinctly in his defense or set off or counterclaim founded upon these separate grounds. New ground of defense, friends. Any ground of defense which has arisen after institution of a suit or after the presentation of the written statement claiming a set off or counterclaim may be raised by the defendant or the plaintiff, as the case may be, in his written statement. Okay, once the plaintiff has been presented, a written statement is filed. If a new fact has been coming, a new ground of defense can be taken. Any ground of defense which has arisen after the institution of the suit or the presentation of a written statement claiming a set off or counterclaim may be raised by the defendant or plaintiff, as the case may be, in his written statement. It means that once a plaint has been filed, a new ground of defense can be taken in the written statement. Once the written statement in answer to a counterclaim has been filed, if the plaintiff wants to file his written statement in answer to a counterclaim, he may take a new ground of defense against the counterclaim or set off of the defendant, friends. That's about 8, Rule 8. Now, friends, we have discussed all these. Okay, today's important concept, that is counterclaim and set off. Okay. Now let us see the differences between counterclaim and set off. Okay, this is rule 9. Let us see this one also. Subsequent pleadings is stated under order 8 rule 9. No pleading subsequent to the written statement of a defendant other than by way of defense to set off or counterclaim shall be presented except by the leave of the court. By the leave of the court. If any defense has been already set up, once the plaint and written statement have been filed, once the plaint is filed and once the counterclaim or written statement or set off has been filed, then the plaintiff has a right to file his written statement in answer to the counterclaim or in answer to the set off. It is his liberty, friends. Then after filing a written statement in answer to the counterclaim, still the defendant wants to file some additional or subsequent pleadings. With the leave of the court, he may file an additional written statement in answer to the written statement to the counterclaim of the defendant. Therefore, with the leave of the court, by the leave of the court, upon such terms as the court thinks fit, they may file the subsequent pleadings. Otherwise, there are no subsequent pleadings to the written statement of the defendant other than by way of defense to a set off or counterclaim. But the court may at any time require a written statement or additional written statement from any of the parties and fix a time not more than 30 days for presenting the same. That is about rule 9, friends. Now let us see the key differences between set off and counterclaim. Okay. Set off and counterclaim. Now, the first one, set off, friends. Set off is related to only for ascertained values, only for an ascertained value. Or ascertained sum of money, whereas the counterclaim, ascertained sum is not a criteria to fix or to put the counterclaim, friends. It is not a criteria. The second one, the second difference in between set off and counterclaim is that the set off arises out of the same transaction in equitable set off. Okay. In case of equitable set off, friends. Whereas in case of counterclaim need not arise with regard to the same transaction. Okay. For instance, if a plaintiff has filed a suit for permanent injunction, the defendant may put his counterclaim for declaration of title also. Okay. Therefore, it may not be related to the same transaction. Set off is a statutory ground of defense whereas it is not a statutory, it does not afford any defense, friends. It is not a defense, it is a counter attack. It is not a defense, friends, it is a counter attack upon the plaintiff. The next difference in between the set off and counterclaim is that it cannot exceed the plaintiff's value, but whereas the counterclaim may exceed the plaintiff's claim. Thereafter, it is the no cross action, friends. There is no cross action. Whereas a counterclaim, it is a cross action against the plaintiff, friends. This is about the concept of set off and counterclaim. This is about the concept of set off and counterclaim. Friends, do you have any doubts regarding this subject? Okay, feel free to contact me, type your comments here, and get your doubts resolved during this live session itself. Friends, do you have any doubts? Joy Ritaji, good evening. Do you have any doubts regarding the subject? Okay. Friends, if you want to compete with thousands of aspirants and to stand out from the crowd, get Unacademy Judiciary subscription today. Okay. Get Unacademy Judiciary subscription. Unacademy is the India's largest education platform. It has been providing free live classes plus classes for plus subscribers and YouTube classes for the aspirants. Therefore, friends, let us crack judiciary services examinations with Unacademy. Get your subscription today. You can also use the code SUBHANLIVE SUBHANLIVE in order to avail 10% of offer the subscription amount. Friends, apart from these live classes in YouTube, Unacademy Judiciary has its learner app. You can download the same from Play Store or App Store, and you can get access to all free special classes conducted by the top educators on every day. Friends, these free live classes will cover all the subjects of law, especially Indian Contract Act, Civil Procedure Code, jurisprudence, Hindu law, constitutional law, Criminal Procedure Code, Indian Evidence Act, Indian Penal Code, all local laws of your respective states. Friends, apart from these, okay, if the judiciary services examinations of your state prescribe any other laws, those laws can also be taught by way of free classes. Friends, these are the special features of the special class. Friends, these these free classes, these classes are interactive live classes. Friends, you can attend these live classes, you can participate in the live chat, you'll get your doubts cleared during the live session itself. Friends, there is an option for poll for the learners. You can respond to the polls for a better understanding of a topic. You can raise your hand. Okay, the plus subscribers can directly talk with the educators in the live class, and they can get the doubts resolved in the real time. Friends, you will get notified for all the lessons, upcoming courses, upcoming recommendations as curated for you. You never miss any class. You will get notified through the notifications of Unacademy Judiciary. Friends, the lecture notes will be provided by way of PDF notes. Friends, you can download the lecture notes by way of PDF and get access to the recorded sessions of the live classes. If you miss any live class, you can revisit the important topics whenever you need for the same. Friends, you can watch these classes at any time and anywhere. If you have any electronic gadget having internet connection like mobile phone, laptop, PC or tablet, you can watch these live classes at any time from anywhere from your electronic device having internet connectivity. Friends, once you get the plus subscription from Unacademy Judiciary, you will get the access to all the services of Unacademy Judiciary. Friends, you will get India's best educator, the classes of India's best educators. You can get interactive live classes. You can take the live tests, mock tests, live tests, etc. Friends, you can participate in the quizzes. You can analyze your own skills. Friends, you can get the structured courses and PDF notes. Okay, these are the additional benefits for the plus subscriber. These are the exclusive benefits of the plus subscribers. Friends, these are the special offers for Unacademy Judiciary. Friends, if you get 12-month subscription, you'll get 1 month subscription free. If you buy 18-month subscription, you can get 2 months subscription free. If you buy 24-month subscription, then get 4 months subscription absolutely free. Friends, this offer is ending very soon. Therefore, subscribe Unacademy Judiciary and crack the judiciary services examinations. Friend, with the name of T20 mock test series, Unacademy Judiciary has been conducting the mock tests on core subjects of judiciary, especially on IPC, CRPC, CPC, and Evidence Act. From Monday to Friday, on every Monday there will be an IPC class, IPC mock test at 9 a.m. to 9:30 a.m. On every Tuesday there will be a mock test in between 9 a.m. to 9:30 a.m. on CRPC. On every Wednesday in between 9 a.m. to 9:30 a.m. there will be a mock test on CPC. On every Thursday there will be a mock test on Indian Evidence Act in between 9 a.m. to 9:30 a.m. Friends, on every Friday there will be a mixed bag series. All the subjects will be covered in the T20 mock test, which was conducted daily basis on every Friday. On every Saturday and Sunday, in between 7 p.m. to 8 p.m., there will be a detailed analysis of all these tests. Therefore, it is a great opportunity, friends. You can take all these tests. Apart from this, Unacademy Judiciary is also conducting the batch courses, friends. The top educators of Unacademy have curated the detailed batch courses to provide you with everything you need to crack your judiciary services examination. A batch has been already commenced on 7th July, 15th September, 8th September, 6th October, 13th October, 27th October. Recently, a new batch has been started on 3rd November. Friends, you can also join any of these batches, and you can continue the live classes from today, and you will have access to watch the recorded sessions of all these batches also. Why are you waiting for, friends? Block your calendar now and get Unacademy Judiciary subscription today. Friends, with the name of Aramb, Unacademy Judiciary has started a free test series for Rajasthan and Haryana Judiciary Services examinations for the year 2020. You can mark your calendars and strengthen your weak points. Take these free full-length mock tests to get ready for your examinations. Friends, for Rajasthan Judiciary Services, the 3 mock tests were already completed. For Rajasthan Judiciary Services, 1 mock test has been completed. Now, on 14th November at 6 p.m., there will be a mock test conducted for Rajasthan Judiciary Services, and on 21st November at 6 p.m. there will be a mock test for Rajasthan Judiciary Services. Friends, apart from the aspirants of Rajasthan Judiciary Services and Haryana Judiciary Services, the aspirants who are preparing for judiciary services examinations of other states can also avail this great opportunity to take these full-length mock tests in order to assess your capacity or your caliber to write the examinations, because the judiciary services examinations of other states also having the same subjects like IPC, CRPC, C.P.C, Evidence Act, Transfer of Property Act, Limitation Act, Specific Relief Act, Juvenile Justice Act, Domestic Violence Act. These are common, friends. These are common for all the judiciary services examinations of all the states. Therefore, it is a great opportunity for students or aspirants of other states also to utilize this great opportunity. Friends, with the name of Rapid Revision Series for Rajasthan Judiciary and Haryana Judiciary Services, Karan Sanwangji, Viswani Bansalji and Faizan Kanji has commenced rapid revision on 18th October 2021 onwards. Friends, these are the pricing plans for plus subscription: 1 month plan, 3 months plan, 6 months plan, 12 months plan, 18 months and 24 months plans are available. These are the subscriptions for various plans, friends. You can also use the code SUBHANLIVE SUBHANLIVE in order to get 10% of offer in Unacademy Judiciary subscription amount. Friends, Unacademy has started Unacademy Judiciary YouTube channel and Unacademy Telegram channel. You can also join in Telegram channel. You will get notified all upcoming classes, upcoming batches, upcoming courses, upcoming offers, etc. if you join in Unacademy Judiciary Telegram channel. Friends, my live classes are available exclusively on Unacademy Judiciary YouTube channel on every Tuesday and Thursday at 9 p.m. Okay. Subscribe Unacademy Judiciary channel. Share these videos. Okay. Type your comments here. Okay. Like these videos. Friends, stay tuned with Unacademy Judiciary. Let us crack it. Thank you. Thank you very much.